What is arrest? An arrest is a taking of a person in custody in order that he may be bound to answer for the commission of an offense, and that is under Section 1, Rule 113 of the Rules of Court. How is an arrest made? Arrest is made by an actual restraint of the person to be arrested, or by his submission to the custody of the person making the arrest. So in making an arrest, a person need not be actually restrained by the person making the arrest. Under the rules of court, a submission to the custody of the person making the arrest already constitutes an arrest. Section 2 of Rule 113 Rules of Court. Whichever means is used to make an arrest, the term necessarily implies control over the means under custody, and as a consequence, a restraint on his liberty to the extent that he is not free to leave on his own volition. What does it mean when jurisprudence says that the officer in making the arrest must stand his ground? It means that the officer may use such force as is reasonably necessary to effect the arrest. It has been held that neither the application of actual force, manual touching of the body, or physical restraint, nor a formal declaration of arrest is required for arrest to exist. It is enough that there be an intention on the part of one of the parties to arrest the other, and that there be an intent on the part of the other to submit, under the belief and impression that submission is necessary. Thus, when a motorist is flagged down for a traffic violation, he is not deemed to be under arrest at the time that he was waiting for the traffic officer to write the citation ticket. The period prior to the issuance of the ticket may be characterized merely as waiting time, where there is no intent to take the motorist into custody. That is under Luce versus People, 667 SCRA 421. Under the same case, when there is an intent on the part of the police officer to deprive the motorist of his liberty, or to take the same into custody, the police officer may be deemed to have arrested the motorist. What is the duty of the arresting officer who arrests a person? He must deliver the person immediately to the nearest jail or police station. An underlying rule governing arrests is the prohibition against the use of violence or unnecessary force in making an arrest. The rule emphasizes that no person arrested shall be subject to a greater restraint than is necessary for his detention. Within what period must a warrant of arrest be served? There is no time period. Under Section 6, Rule 113 of the Rules of Court, an arrest may be made on any day at any time of the day or night. A warrant of arrest is valid until the arrest is effected or until it is lifted. The head of the office to whom the warrant was delivered must cause it to be executed within 10 days from its receipt, and the officer to whom it is assigned for execution must make a report to the judge who issued it within 10 days from the expiration of the period. If he fails to execute it, he should state the reasons thereof. And when making an arrest by virtue of a warrant, the officer shall inform the person to be arrested of the cause of his arrest and the fact that a warrant has been issued for his arrest. The information, however, may not be given if the person to be arrested flees, forcibly resists, or the giving of the information will imperil the arrest. Under Section 7, Rule 113. Can an officer arrest a person against whom a warrant has been issued even if he does not have the warrant with him? Yes, the officer need not have the warrant in his possession at the time of the arrest. However, after the arrest, the warrant shall be shown to the person arrested as soon as practicable, if the person arrested so requires. Can an arresting officer ask assistance from bystanders in effecting the arrest? Sometimes it happens that an officer cannot, on his own effectively make the arrest. Hence, the right and duty of an officer to effect an arrest in proper cases carries with it the authority to orderly summon as many persons as he deems necessary to assist him in effecting the arrest, and every person so summoned by an officer is required to give the assistance requested, provided he can do so without detriment to himself. Section 10, Rule 113. The duty of the person summoned, however, does not arise when rendering assistance would cause harm to himself. What happens when the person to be arrested is inside a building? If the person to be arrested is or is reasonably believed to be within any building or enclosure, the rule authorizes the officer in order to make an arrest to break into any building or enclosure if he is refused admittance thereto, after announcing his authority and purpose. Section 11 of Rule 113 Rules of Court. After entering the building or enclosure, he may break out from said place if necessary to liberate himself from the same place. Section 12. When is an arrest without warrant lawful? The general rule is that a warrant of arrest is required before an arrest is made, but a peace officer or private person may arrest without warrant when 1. When in his presence the person to be arrested has committed or actually committing or is about to commit an offense. 2. When an offense has just been committed and he has probable cause based on personal knowledge of facts and circumstances that the person to be arrested has committed it. And 3. When a person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment, or is temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another. See Howe versus People, GR 183345, September 17, 2014, or People versus Adriano, GR 208169, October 8, 2014, and Omer versus People, GR 182534, September 2, 2015. There are other grounds for a lawful warrantless arrest other than those provided above. That is, when a person previously lawfully arrested escapes or is rescued, any person may immediately pursue or retake him without a warrant at any time and in any place within the Philippines. Section 13, Rule 113. When an accused released on bail attempts to depart from the Philippines without permission of the court where the case is pending, he may be rearrested without a warrant. Section 23, Rule 114. Who may be authorized to make the warrantless arrest? Under Section 5 of Rule 113 of the Rules of Court, a peace officer or a private person may without a warrant arrest a person when in his presence the person to be arrested has committed, or is actually committing, or is attempting to commit an offense. This is known as arrest in Flagrante Delicto. The arrest made by a private person under the circumstances provided for under the rule is usually called a citizen's arrest. But in Flagrante Delicto, making an arrest based on mere suspicion and reliable information are not justifications for a warrantless arrest. Such words are not found in the rule. On the contrary, the rule requires that the accused perform some overt act that would indicate that he has committed, or is actually committing, or is attempting to commit an offense. Jurisprudence instructs that for a warrantless arrest of a person caught in flagrante delicto under paragraph A of Section 5 to be valid, two requisites must concur. The person to be arrested must execute an overt act indicating that he has just committed, or is actually committing, or is attempting to commit a crime. And such overt act is done in the presence or within the view of the arresting officer. People v. Collado, 698, Squa, 628, June 17, 2013. Therefore, in this type of warrantless arrest, the person making the arrest himself witnesses the crime and hence has personal knowledge of the commission of the offense. People versus Villarreal 693 Scra 549 March 18, 2013, as when, for example, he sees Mr. A fire a gun at Mr. B. An example of an arrest in Flagrante Delicto is one made after conducting a buy-bust operation, People versus Colado 698 Scra 628. An arrest made after an entrapment operation does not require a warrant inasmuch as it is considered a valid warrantless arrest. Considering that an arrest was lawfully made, the search incidental to such arrest was also valid. A person lawfully arrested may be searched without a search warrant for dangerous weapons or anything which may have been used or constitute proof in the commission of an offense. People versus Almudial 680 Scra 308. However, when the accused was arrested while merely talking to a police informant, and there was no overt act indicative of a felonious enterprise that could be properly attributed to the said accused to arouse suspicion in the mind of the arresting officer that the accused had just committed, or was actually committing, or was attempting to commit a crime, the warrantless arrest was not valid. The accused and the informant were just talking to each other, and there was no exchange of money and drugs when he approached the car, as testified by the arresting officer. He also admitted on cross-examination that he had no personal knowledge on whether there was a prohibited drug and gun inside the vehicle of the accused when he approached. People versus Idanio. GR 188133, July 7, 2014. Flight per se is not synonymous with guilt and must not always be attributed to one's consciousness of guilt. The mere act of darting away when approached by a police officer should not be construed against the accused. It is not a reliable indicator of guilt without other circumstances. An attempt to run away from an officer is susceptible of various explanations. It could signify guilt or may signify innocence. There are many innocent reasons for flight, like fear or retribution for speaking to an officer, unwillingness to appear as witness, and a fear of being apprehended even if he is innocent. Also, the act of walking along the streets and holding something in one's hand, even if they appear to be dubious, coupled with his previous criminal charge for the same offense, are not by themselves sufficient to incite suspicion of criminal activity or to create probable cause enough to justify a warrantless arrest. People versus Villarreal, March 18, 2013. On the same case, the court also instructed that it would be error to rule in favor of the validity of a person's arrest based on personal knowledge of facts regarding appellant's person and past criminal record. Even a previous arrest or existing criminal record, even for the same offense, will not suffice to satisfy the exacting requirements provided under Section 5, Rule 113, in order to justify a lawful warrantless arrest. More recently, it was held that the argument that the accused attempted to run away when the officer arrested him is irrelevant and cannot by itself be construed as adequate to charge the police officer with personal knowledge that the appellant had just engaged in, was actually engaging in, or was attempting to engage in criminal activity. Flight per se, once again, is not synonymous with guilt and must not always be attributed to one's consciousness of guilt. It is not a reliable indicator of guilt without other circumstances, for even in high crime areas there are many innocent reasons for flight, including fear of retribution for speaking to officers, unwillingness to appear as witnesses, and fear of being wrongfully apprehended as a guilty party. Lifted from 2010 Bar. People versus Idanio GR 188133. Oh, and by the way, let me seize your attention and direct you to go ahead and hit that subscribe button and be notified with my next legal audios. Do you know that it makes me feel good about myself when you subscribe and let those ads play? Yeah, it does. Thanks. In Commerciante versus People with GR number 205926, July 22, 2015, the court rejected the validity of an arrest made by an officer on the basis of his observation that the accused was standing around and showing improper and unpleasant movements. Such acts, declared the court, cannot be considered criminal acts. At that time, the officer was aboard a motorcycle cruising at a speed of 30 kilometers per hour when he allegedly saw the accused while standing on the side of a street, handing over something to another at a distance of 10 meters. The court found it highly implausible, even assuming that he had a perfect vision, to have been able to identify minuscule amounts of crystalline substances inside two plastic sachets. In another case, the court declared as inadmissible in evidence the marijuana found in possession of the accused as a product of an illegal search, since it was admittedly made not as an incident of a lawful arrest. The Supreme Court declared that the accused was not, at the moment of his arrest, committing a crime, nor was it shown that he was about to do so, or that he had just done so. He was merely descending the gangplank of the ship, holding a bag, and there was no outward indication that called for his arrest. To all appearances, he was like any of the other passengers innocently disembarking from the vessel. It was only when the informer pointed to him as the carrier of the marijuana that he suddenly became a suspect, and so subject to apprehension. The court added that from the information received by the officers, they could have obtained a warrant since they had at least 2 days to apply for the same. But the officers made no effort to comply with the Bill of Rights. They chose to ignore the law. The Bill of Rights was ignored altogether because the head of the arresting team had determined on his own authority that a search warrant was not necessary. Another case, in the case of People v. Molina 352-174, the conviction by the trial court was reversed and set aside when the Supreme Court declared as invalid an arrest made merely on the basis of reliable information that the persons arrested were carrying marijuana. The accused were arrested while inside a pedicab despite the absence of any outward indication of a crime being committed. Here, the court unequivocally ruled that as applied to in flagrante delicto arrest, it is settled that reliable information alone, absent any overt act indicative of a felonious enterprise in the presence and within the view of the arresting officers, are not sufficient to constitute probable cause that would justify an in flagrante delicto arrest. In another case, in the case of Malacat v. Court of Appeals, the Supreme Court declared that a warrantless arrest cannot be justified where no crime is being committed at the time of the arrest because no crime may be inferred from the fact that the eyes of the person arrested were moving fast and looking at every person passing by. In the case of People v. Mengote 210-174, he was seen looking from side to side, clutching his abdomen. The operatives approached the 3 men, including Mengote, introduced themselves as policemen. 2 of them tried to run away, but the attempt was foiled. The search yielded a revolver in the possession of Mengote and a fan knife in the pocket of another. The Supreme Court, through Justice Sagani Cruz, ruled that the requirements of a warrantless arrest were not complied with. There was no offense which could have been suggested by the acts of Mengote of looking from side to side while holding his abdomen. The court said, "These are certainly not sinister acts. He was not skulking in the shadows but walking in the clear light of day. There was nothing clandestine about his being on that street at that busy hour in the blaze of the noonday sun. By no stretch of the imagination could it have been inferred from these acts that an offense has just been committed, or was at least being attempted, in their presence." People v. Mengote 210-174. Another case is the case of People v. Lagio Jr. 518-393. In this case, 2 men were arrested while they were about to hand over a bag of shabu to a police officer. When they were questioned, the arrested men told the officer that they knew of a scheduled delivery of shabu by their employer, WW, early the following morning, and that he could be found at a certain apartment building in Malate, Manila. The police operatives decided to look for WW to shed light on the illegal drug activities of his alleged employees and proceeded to the location of the apartment and placed the same under surveillance. When WW came out of the apartment towards a parked car, two other police officers approached him, introduced themselves to him as police officers, asked his name, and upon hearing that he was WW, immediately frisked him and asked him to open the back compartment of the car. When frisked, there was found inside the front right pocket of WW an unlicensed pistol with live ammunition. At the same time, the other members of the operatives searched the car and found inside it were the following items: 1 transparent plastic bag with shabu, 2 cash in the amount of 650,000, 3 electronic and mechanical scales, and 4 another unlicensed pistol with magazine. Then and there, WW resisted the warrantless arrest and search. The Supreme Court, in very lucid terms, declared that the facts and circumstances surrounding the case did not manifest any suspicious behavior on the part of WW that would reasonably invite the attention of the police. He was merely walking from the apartment and was about to enter a parked car when the police operatives arrested him, frisked and searched his persons, and commanded him to open the compartment of the car. He was not committing any visible offense then. It is settled, said the court, that reliable information alone, absent any overt act indicative of a felonious enterprise in the presence and within the view of the arresting officers, is not sufficient to constitute probable cause that would justify an in flagrante delicto arrest. The court concluded that there can be no valid warrantless arrest in flagrante delicto under paragraph A of section 5 of Rule 113. People v. Slagud Jr., citing People v. Binad C. Chua, 444 Phil 757, and People v. Molina, 352 Scra 174. In the case of People v. Claudio, the Supreme Court upheld the validity of a warrantless arrest under the in flagrante delicto. The accused in this case was carrying a woven, brie-like plastic bag which appeared to contain camote tops, boarded a bus bound to the province. Instead of placing the bag by her side, which is the usual practice of a traveler, she placed the same on the back seat where a trained anti-narcotics agent was seated. Since the act of the accused was unusual for a traveler, the suspicion of the agent was aroused. Feeling that something was unusual, the agent inserted his finger inside the bag where he felt another plastic bag in the bottom, from which emanated the smell of marijuana. Right after she got off the bus, the agent arrested the accused. In the case of People v. Tangliben, two police officers together with a barangay tanod were conducting surveillance operations in a bus station allegedly to check on persons who may be engaging in the traffic of dangerous drugs based on information supplied by informers. They noticed a person carrying a red traveling bag who was acting suspiciously. When asked to open the bag, the accused did so only after the officers identified themselves. Found in the bag were marijuana leaves wrapped in plastic and weighing about 1 kilogram. Upon these facts, it was ruled that there was a valid warrantless arrest and a valid warrantless search. The court pronounced Tangliben to be different from Aminuddin. In the latter, the urgency presented by Tangliben was not present. In Tangliben, the court found that the officers were faced by an on-the-spot information which required them to act swiftly. In the case of People v. Maspil, a confidential report from informers said that two persons would be transporting a large quantity of marijuana, so officers set up a checkpoint in Benguet to monitor, inspect, and scrutinize vehicles bound for Baguio City. A couple of hours after midnight, a jeepney was flagged down in the checkpoint. On board were the persons identified by the informers who were also with the policemen manning the checkpoint. When the sacks and tin cans inside the jeepney were opened, they contained marijuana leaves. The policemen then placed the two accused under arrest. The court distinguished Maspil from Aminuddin. In the latter, the officers were aware of the identity of the accused, his planned criminal enterprise, and the vessel he would be taking. Further, so the officers had sufficient time to obtain a search warrant. In Maspil's case, the officers had no exact description of the vehicle of the accused and no idea of the definite time of its arrival. The court explained that a jeepney on the road is not the same as a passenger boat, the route and time of arrival of which are more or less certain and which ordinarily cannot deviate or alter its course or select another destination. In the case of Umil versus Ramos, 202-251, one of the accused was arrested without a warrant while he was confined in the hospital and undergoing treatment for a gunshot wound. The validity of his arrest was sustained by the court. Among other reasons, his arrest without a warrant was held to be justified because when he was arrested, he was deemed to be in the act of committing an offense for being a member of the New People's Army, an outlawed organization where membership was penalized. He was also arrested for subversion, which, like rebellion, is a continuing offense as held by the court in Garcia Padilla versus Enrile. Umil versus Ramos, 202-251. Still on warrantless arrest. A warrantless arrest made 1 year after the offense was allegedly committed is an illegal arrest. A warrantless arrest effected the day after the commission of the crime of robbery with homicide does not fall within the purview of hot pursuit exception. The requirement of immediacy between the time of the commission of the crime and the time of the arrest is absent. People versus Del Rosario. In People versus Sendana, 190-538, an arrest made based on information from unnamed sources a day after the crime was committed was held to be invalid. In Rolito Go versus Court of Appeals, the accused was arrested 6 days after the commission of the crime. The arrest was held invalid because the offense has not just been committed. In Posadas versus Ombudsman, a warrantless arrest was invalidated because it was made 3 days after the commission of the crime. It must be emphasized that the personal knowledge referred to under the hot pursuit exception does not refer to actual knowledge of the crime because the officer did not witness its commission. The knowledge referred to is knowledge that a crime was committed even if it was not committed in his presence. As explained by the court, under the Flagrante Delicto exception, the person making the arrest himself witnesses the crime. In the hot pursuit exception, the person making the arrest knows for a fact that a crime has been committed. People versus Villarreal. The person making the arrest has personal knowledge of the fact that a crime was committed because at the time of the arrest, he has reasonably worthy information in his possession coupled with his own observation and fair inferences therefrom that the person arrested has probably committed the offense. The arresting officer may even rely on information supplied by a witness or a victim of the crime. Pestillas versus Generoso, 739-337. Personal knowledge of facts must be based on probable cause, which means an actual belief or reasonable grounds of suspicion. The grounds are reasonable when the suspicion that the person to be arrested is probably guilty of committing the offense is based on actual facts, that is, supported by circumstances sufficiently strong in themselves to create the probable cause of guilt of the person to be arrested. A reasonable suspicion, therefore, must be founded on probable cause coupled with good faith on the part of the peace officers making the arrest. Abilita versus Doria, 596-SCRA 220. In People versus Acol, 232-SCRA 406, 2 robbers divested the passengers of a jeepney of their belongings, including the jacket of one passenger. The passengers immediately sought the help of police officers, which formed a team to track down the suspects. One of the passengers, who went with the responding police officers, saw one of the robbers casually walking in the same vicinity and wearing his jacket. The warrantless arrest of the accused was sustained by the court as well, within the hot pursuit exception. In People versus Llorente, the Valenzuela police station received a report of a mauling incident which resulted in the death of the victim, who received a massive skull fracture caused by a hard and heavy object. The policemen saw the dead victim in the hospital and saw the instruments of death in the crime scene. Right away, the officers went to the crime scene and found a piece of wood with blood stains, a hollow block, and 2 pouches of marijuana. A witness told the police that the accused was one of those who killed the victim. They proceeded to the house of the accused and arrested him some 3 hours after the alleged killing. The court ruled that based on their knowledge of the circumstances of the death of the victim and the report of an eyewitness in arresting the accused, the officers had personal knowledge of facts leading them to believe that it was the accused who was one of the perpetrators of the crime. In Delicto versus Doria, the petitioner alleged that he was arrested based merely on information relayed to the police officers about a shooting incident and that they had, at the time of the arrest, no personal knowledge of the facts. The court found that as soon as the police received a phone call about a shooting incident, a team was dispatched to investigate. The investigation disclosed that a victim was wounded and that the witnesses tagged the petitioner as the one involved and that he had just left the scene of the crime. After tracking down the petitioner, he was invited to the police headquarters, but the petitioner, who initially agreed, sped off, prompting the authorities to give chase. The court ruled that the petitioner's act of trying to get away, coupled with the incident report, which they investigated, is enough to raise a reasonable suspicion on the part of the police authorities to the existence of a probable cause. In a recent case, the arresting officers went to the scene of the crime upon complaint of the offended party that he was mauled less than an hour after the alleged mauling. They saw the bloody state of the victim and how the latter identified the assailants. The accused, when confronted by the police, did not deny the mauling, although they gave another version of the incident. These circumstances qualify as to the officer's personal knowledge of the commission of a crime to justify the warrantless arrest. Pastillos versus Generoso, 739 SCRA 337. What are the rights of the person arrested? The rights of a person arrested, detained, or under custodial investigation are spelled out by RA 7438. These rights are the right to be assisted by counsel at all times. B. The right to remain silent. C. The right to be informed of the above rights. D. The right to be visited by immediate members of his family, by his counsel, or by any non-governmental organization, national or international. The counsel must be one who is independent and competent. He shall be allowed to confer at all times with the person arrested, detained, or under custodial investigation. If such person cannot afford the services of his own counsel, he must be provided by the investigating officer with a competent and independent counsel. In the absence of a lawyer, no custodial investigation shall be conducted, and the suspected person can only be detained by the investigating officer in accordance with the provisions of Article 125 of the Revised Penal Code. Also, any waiver of the provisions of Article 125 of the Revised Penal Code shall be in writing and signed by the person arrested, detained, or under custodial investigation in the presence of his counsel. Otherwise, the waiver shall be null and void and of no effect. Any extrajudicial confession made shall also be in writing and signed by the person detained or under custodial investigation in the presence of his counsel, or in the latter's absence, upon a valid waiver, and in the presence of any of the parents, older brothers and sisters, his spouse, the municipal mayor, the municipal judge, district school supervisors, or priest or minister of the gospel as chosen by him. Otherwise, Such extrajudicial confession shall be inadmissible as evidence in any proceeding. In People v. Gillen, the records show that the appellant, after being arrested, remained silent and passive when he was identified in the police station by his alleged rape victim. This silence was interpreted by the trial court as equivalent to an implied admission of guilt and found him guilty of rape beyond reasonable doubt. The conviction was affirmed by the Court of Appeals. But in the Supreme Court, the appellant claimed that his silence should not have been used against him because in remaining silent when he was confronted by his alleged victim, he was just exercising his constitutional rights to remain silent. The Supreme Court agreed with the appellant. The court observed that when the appellant was brought to the police station, he was already suspected to the crime of rape. As such, he was already under custodial investigation within the purview of the Constitution. When does custodial investigation begin? Custodial investigation, as a rule, begins to operate as soon as the investigation ceases to be a general inquiry into an unsolved crime, and the interrogation is then aimed on a particular suspect who has been taken into custody and to whom the police would then direct interrogatory questions that tend to elicit incriminating statements. Luspo v. People, 739 SCRA 133. RA 7438 expanded the meaning of custodial investigation. Under Section 2, letter F of the Act, custodial investigation shall include the practice of issuing an invitation to a person who is investigated in connection with an offense he is suspected to have committed, without prejudice to the liability of the inviting officer for any violation of law. This means that even those who voluntarily surrendered before a police officer must be apprised of their Miranda rights. For one, the same pressures of a custodial setting exist in this scenario. People v. Chavez, GR 207950. The right to counsel upon being questioned for the commission of a crime is part of the Miranda rights, which require that. So, what is the effect of an illegal arrest on jurisdiction of the court? The illegality of the arrest cannot in itself be the basis for acquittal. People v. Yao, GR 208170. It will not negate the validity of the conviction of the accused. Rebellion v. People. Also, even if the warrantless arrest of an accused is later proven to be invalid, such fact is not a sufficient cause to set aside a valid judgment rendered upon the sufficient complaint after a trial free from error. People v. Velasco, 710 SCRA 784. Also, an application for or admission to bail shall not bar the accused from challenging the validity of his arrest or the legality of the warrant issued, provided that he raises the objection before he enters his plea. The objection shall be resolved by the court as early as practicable, but not later than the start of the trial of the case. So, any objection involving a warrant of arrest or the procedure by which the court acquired jurisdiction of the person of the accused must be made before he enters his plea. Otherwise, the objection is deemed waived. People v. Velasco. However, the principle that the accused is precluded after arraignment from questioning the illegal arrest or the lack of or irregular preliminary investigation applies only if the accused voluntarily enters his plea and participates during the trial without previously invoking his objection thereto. La Vista v. Alameda. In the case of Rebellion v. People, the records disclose that the petitioner was duly arraigned, entered a negative plea, and actively participated during the trial. Thus, he was deemed to have waived any perceived defect in his arrest and effectively submitted himself to the jurisdiction of the court trying his case. When a person fails to make a timely objection of an illegal arrest, only the right to assail the arrest is waived. he does not waive the right to question the admissibility of the evidence seized by virtue of the illegal arrest. Jurisprudence holds that a waiver of an illegal warrantless arrest does not mean a waiver of the admissibility or inadmissibility of evidence seized during an illegal warrantless arrest. People v. Martinez. A later case similarly emphasizes that while the accused may have already waived his right to contest the illegality of the arrest, he is not, however, deemed to have equally waived his right to contest the legality of the search. Villanueva v. People, DR 199042, November 17, 2014. Who are persons not subject to arrest? Section 11, Article 6 of 1987 Constitution provides that a senator or member of the House of Representatives shall, in all offenses punishable by not more than 6 years imprisonment, be privileged from arrest while the Congress is in session. The privilege of a senator or a congressman will not apply when the offense is punishable by imprisonment of more than 6 years, even if Congress is in session. People v. Halos Haas. Also, the privilege does not apply if Congress is not in session. Section 11, Article 6 of the Philippine Constitution. Under generally accepted principles of international law, sovereigns and other chiefs of state, ambassadors, ministers, plenipotentiary ministers, resident, and chargé d'affaires are immune from the criminal jurisdiction of the country of their assignment and are therefore immune from arrest. RA 75 prohibits the arrest of duly accredited ambassadors, public ministers of a foreign country, their duly registered domestics, Section 4 RA 75, subject to the principle of reciprocity. That is also under Section 7 RA 75. And we're done with the rest. Please don't forget to hit that subscribe button. I really appreciate your support. Thank you.